This is day 14 of the 30 days Know Your Karma challenge. Gosh, I think the hardest part of anything is not starting, it's in the consistency. The hardest part of running your company is not in the incorporation. I think that's the most easiest part. It's in the running your company and running it well. Today on day 14, we are discussing sections 293 to 340. Still talking about directors, wrapping it up, and then looking at secretaries. Sections 293 talks about the remuneration of directors. So, the remuneration of the directors are decided by the members at the general meeting, and directors are entitled to travel allowances, hotel, and other expenses that they incur reasonably incur in attending and returning from the meetings of the directors, committee meetings, general meetings, and any other thing that they do in connection with the business of the company. I need to add that section 293 sub 4 says that the company is not bound to pay remuneration to directors, yes, but where the company agrees to pay, the director shall be paid such remuneration out of the funds of the company. Remuneration of managing director, sections 294, and I'm going to read it. A managing director receives such remuneration whether by way of salary, commission, participation in profits, or partly in one way and in another, as the directors may determine. Do you see the difference? Remuneration of the directors is determined by the company in general meeting, which is by the members, but the remuneration of the managing director is determined by the directors. I also need to add that the remuneration of the directors are not tax free. Section 295, prohibition of loans to directors. So it is not lawful for a company to make a loan to any person who is a director or is a director of its holding company, or to enter into any guarantee or provide any security in connection with a loan made to such a person. There are exceptions to this rule, and those exceptions are outlined in 296. And I know that you can give loan where the director needs this loan for the running of the business, and there are procedures to giving these loans. Where it is in the normal business of the company to give loan, then they can give these loans. But there are also modalities and approvals that are necessary. Sections 296 addresses all of that. One thing to note is in sections 301 that talks about the register of directors shareholding. Just reads that every company shall keep a register showing as respects each director of the company, not being its holding company, the number, description, and amount of shares in the ventures of the company or any other body corporate, being the company's subsidiary, holding company, or a subsidiary of the company's holding company, which are held by or in trust for him, or of which he has any right to become the holder. And like every other register, the register shall be open for inspection and it shall be kept at the registered office of the company. Another important aspect is the disclosure by the directors of, of their interests in any contract. So, where a director is going to be either directly or indirectly gaining from a contract or has any personal interest, it is his duty to inform the directors in writing, detailing particulars of such interest. Sections 303 addresses this. Another important aspect that most companies may default in is section 304 that says that every company to which this section applies shall, in all trade circulars, show cards, and business letters on or in which the company's name appears and which are issued or sent by the company to any person in Nigeria, state in legible characters with respect to every director, his present full name or initials and present surname, any former name and so or surname. This does not apply to women who probably have a change of name by marriage, and the director's nationality if he is not Nigerian. So where you have directors who are not Nigerian, you should state their nationality. We move to the next, which is very interesting. And if you've been up, if see, listen, I have seen most of you in corporate companies, and you just say, "Ah, add my wife as director, add my brother as director." You that they are adding, listen to your duties. Listen, sections 305. A director shall stand in a fiduciary relationship towards the company and shall observe utmost good faith towards the company in any transaction with it or on its behalf. It just simply says that the director shall always have the best interest of the company at heart. Every personal interest is laid aside. Subsection 3 of 305 goes further to say a director shall act in all times in what he believes to be the best interest of the company as a whole, so as to preserve its assets, further its business, and promote the purpose for which it was formed in such manner as a faithful, diligent, careful, and ordinarily skillful director would act in the circumstances, and in doing so shall have regard to the impact of the company's operation on the environment in the community where it carries its business operations. And you would know why I would stress this one. It is your duty as a director to preserve the environment. I think you should check out my is ESG a buzzword up on my podcast and listen, and you know why we stress that. It's also very important to note that a director shall not fetter his discretion to vote in a particular way. Always vote in the best interest of the company. We move to the next, which is the conflict of duties and interests. And if you notice, we keep on stressing that the personal interest of a director shall not conflict with any of his duties as a director under this act. One of it is that he shall not make any secret profits. He shall be accountable to the company for any secret profit that is made by him. And subsection 6 actually addresses when he should make this disclose this interest or secret profits. He should before making the secret profit, not after. Also, very important to note that subsections 4 says the inability or the unwillingness of a company to perform any function or duty under its articles and memorandum does not constitute a defense to any breach of a duty of director under this act. Before you are going to go and they've not paid me, they did not give me my allowance, they did not do this. This that is not an excuse, like we just read. Director owes a duty of care and skill to the company, and failure to take reasonable care in accordance with this section is a ground for an action for negligence and breach of duty. Directors are trustees as seen in sections 309 of the company's money, properties, and their powers, and shall account for all money over which they exercise control, refund any money improperly paid away, and shall exercise their powers honestly in the interest of the company and all shareholders, and not in their own or sectional interests. Sections 313 says a director shall not accept a bribe, a gift, or commission, either in cash or kind, from any person, or share in the profits of that person, kickbacks, in respect of any transaction involving his company in order to introduce his company to deal with such a person. Simply put, no kickbacks. It's also important for us to add that where such gifts are made after the transaction in form of appreciation, it is his duty to actually disclose this to the director. Every company shall keep a register of its directors, which contains the details and particulars of the directors, and such register shall be kept at the head office of the company. And lastly, on directors, where there is any change as to appointments or to the numbers of the directors, it is the duty of the company to notify the CAC. And that's all we can take on directors. And we move to the next, which is the powerhouse of the directors, if that makes sense, the secretaries. Section 330 says that except in the case of a small company, every company shall have a secretary. And you know that it's compulsory for a public company to actually have a secretary. Section 331 addresses a situation where there is an act that is to be done or that is to be authorized by a secretary and a director. It says that where a person is a secretary and a director, we have such situations. That act would not be authorized or seen to be done if it is done by the same person acting both as as a director and in his capacity as the secretary. Can anybody be a secretary? No. The answer is in section 333. People who are qualified to be secretaries: one, member of ICSTANDARDS, the Institute of Chartered Secretaries and Administrators; a legal practitioner; a member of any professional body of accountants; a person who has held office of a secretary of a public company for at least 3 years of the 5 years immediately preceding his appointment in that public company; and a body corporate or firm constitution of members, each of whom is qualified under paragraphs A, B, or C. That's member of ICSA, legal practitioners, or a member of a professional body of accountants. The appointments, as outlined in sections 333, shall be done by the directors and may be removed by them However, where it is intended, I need to also add, and I forgot to add in when I was talking about directors yesterday, removal and resignation are two different concepts. And a lot of people, even lawyers, make this mistake. When you're talking about a person who has resigned or retired, you can't talk about it in terms of removal. No, these are two different concepts. So, where a secretary can resign, that's fine. But if you want to remove that person, it has to be done in accordance with subsections 2 of 333. It's important to note that this company secretary does not owe fiduciary duties to the company in sections 334. So, what then are the duties of the secretary? Sections 335. And duties of a secretary include attending the meeting of the company, the board of directors and its committees, rendering all necessary secretarial services in respect of the meeting and advising on compliance by the meetings with the applicable rules and regulations, maintaining the registers and other records required to be maintained by the company under this act, rendering proper returns and giving notification to the CAC under this act, carrying out such administrative and other secretarial duties as directed by the director or the company. The secretary shall not, within the authority of the board, exercise any powers vested in the directors. Where there's a change to the secretaries, the company shall, within 14 days from such change, notify the CAC. And I think that's all we can take for today, day 14. I'll see you on day 15.